Good evening and welcome to this version of Facebook Live, which you can see on Facebook, YouTube, Twitter, on the Telemundo Noticiero website and the Telemundo Noticiero app. So there are many ways of watching this live every Tuesday, and I remind you that it is in Spanish on Thursday, 7 p.m. West Coast time, 10 p.m. East Coast time. So please share this information. And also, please like my Facebook page. I'd appreciate that. Well, news. I have two big pieces of news. One is, I'm sure you've heard of it. I spoke about it on Thursday, but sometimes we have a different audience in English, so I want to reiterate a little bit about the RAISE Act that was introduced into Congress by two senators from the South, of course, Georgia and Arkansas. And two senators have proposed something called the RAISE Act, which would dramatically change immigration laws. They say it's the biggest change in immigration laws in 50 years, and the President of the United States supports it. Now, in my personal opinion, I think it has low probabilities or chances of passing. However, it has been proposed. It is not law, it is a proposal. So I'm sharing this information, as always, to let you know what is happening, as well as how can we prevent the negative effects of something that may be down the line. If it does become a reality, you know what to do now. So first, what is the RAISE Act? It's changing the immigration system and laws, which have traditionally been known for hundreds of years as a law or immigration law that includes uniting families, that people can bring family members into this country from wherever they are in the world so that they too can be in the United States as permanent residents and later United States citizens. Well, it's changing this family-based criteria to a merit or a point system. So basically what the two senators are proposing is that people that have relationships with family will, the availability of visas through this method will be lessened. And it'll be increased for people that have degrees, high skills. The point system will give points depending on what level of degrees you have, if it's a doctorate, if it's a law degree, if it's a master's, if it's a college graduate degree, or if it's a high school degree. And they'll all have different points, as well as English, and it'll depend on your English level. There'll be TOEFL exams that will allow the government to decide what level your English fluency is at. So if you are fluent, it'll be a certain amount of points. If you barely speak a little bit of English, it'll be a lesser amount of points, or maybe even 0 points. So the point system will allow the government to decide who can enter the United States and who cannot. Now, what is being eliminated from the family-based? Well, sadly, a United States citizen now, and I'll always use myself as an example. I'm a citizen. Today, I can immigrate my mother, my father, my siblings, their spouse, and their children. My spouse, if I'm married, and of course my children, regardless of whether they're married or single, and regardless of age. Well, this proposal seeks to cut in half this relationship that I can have to immigrate people. I will no longer, under the RAISE Act, be able to immigrate my mother or my father or my siblings. I can only immigrate my spouse and my children that are minors and my children that are single. As a resident, the same thing will happen. So it limits who a citizen or a resident, which has a green card, can immigrate into the United States. Now, this is tragic because for Latin American countries, of course, and many Middle Eastern countries and many countries around the world, family is very important and a key element of their lives. So to be able to bring family in because you have obtained citizenship is an added bonus, and to eliminate that will be something very tragic for those that are immigrating into the United States and want to later bring their family. Another elimination is they want to reduce the refugees to only 50,000 per year. And another thing they want to totally do away with is the lottery visa. It's called the diversity visa program. And every year, it's literally a lottery. They select numbers, 50,000, and those selected, wherever they are in the world, can immigrate into the United States and become residents with their family. They want to do away with the lottery program. The beauty of that program was that it sought to kind of level the playing field, bring people from countries where there's a low migration into the United States. So these countries are favored under the lottery program. So this may leave. Now, this is, again, a proposal. It has to go through Congress, and there's also a different version of the bill being introduced or going to be introduced shortly in the House. Now, my take is that there are many Republicans now, or several, that are saying this bill is not okay with us, and we believe in family reunification. So if there are enough Republican senators, and of course the Democrats vote against it, the chances of this becoming a law are slim. However, it's important for me to let you know what's going on in Congress, what they're proposing. As you can see, every day we're seeing this narrowing of benefits and immigration laws getting tighter and tighter. What does this mean for you if you're a citizen or a resident, or you are watching me and you have no status and you have family that's citizens or citizen or a resident, and you're thinking, whoa, are they going to be able to immigrate me in the future? Well, if this law passes, there'll be a cut, of course. But if it does, my recommendation is that you start now. If you're a citizen, you have parents that have been here, they're back home, and you want to immigrate them, now is the time to file for them before laws change if this were to happen. And if you have siblings that you want to petition, now's the time to petition for them as well. Or if you are a citizen and you have children that are now adults and they're married and you have grandchildren and they someday want to come to the United States, now's the time to file for them, just in case this RAISE Act does become law. Hopefully it will not, but it's important that you know what's coming down the pipeline so that you can make decisions and you can actually take action, so that if this happens, at least hopefully it won't be retroactive. And if you already have an application in, it can continue. We don't know that yet. But this is what's been proposed. This is what's being supported by the administration and by the president. So I'm not surprised. I am surprised at what they want to eliminate, because the laws in the United States for decades and decades have been all about bringing family together. So that's the RAISE Act in a very, very brief summary. And if any of you that are watching are United States citizens, I encourage you to write, call, email your senators and say we are against the passage of RAISE Act if this is something you believe in, because they need to hear from citizens that this is not something that they're supporting. So when they decide to take a vote, hopefully they'll take your call and hundreds of other thousands of people that may call into consideration before deciding to vote in favor of the RAISE Act. Well, I'm ready to take some calls, and I do have good news for you, a Ninth Circuit decision, and I'll talk a little bit more about that later. So please stay tuned, because it's really good news.
Thank you so much. And the first question is from Siddiqui. What is the procedure to come to the United States from India? Can you please explain the process and the documentation that you need for verification?
Well, India, I'm looking at my chart, Siddiqui, and there is a list. It's called the Visa Bulletin, and it depends on how you're immigrating, through what family relationship, what country you're from, what job or skill or profession, and it'll give me a breakdown of time frames. So first, you'd have to have a relative that is willing to sponsor you and petition for you to come to the United States, and it can take years. Let me just give you an example. If you have a parent that's a United States citizen and you're from India, the backlog is 2010. That means it would take 7 years for you to get your green card. If you have a sibling, a brother or a sister, and you're from India, they're in 03. That means 2003. That means there's still, about 15, 14 years of wait for you to get a green card. Now, if you have special skills or special professions, many times it's good to come in on some kind of visa. And while you're here, maybe look at the job market, have some interviews, and see if there would be a sponsor within the United States that would want your skills and would want to hire you. And there's some temporary visas. Some skills are so important that there's some permanent residence. So there's just so many ways, Siddiqui, for me. I need to know a lot more about you to be able to narrow in. But my recommendation is that you seek immigration counsel, not in India, in the United States. And many lawyers give consultations all over the world over the phone so that they can interview you, get more information, and then tell you what the best strategy for your particular case is.
Lorenia. I'm Mexican. My husband is a U.S. citizen, but we live in Mexico. We paid a lawyer to start my I-130 procedure, but we discovered that he is not a lawyer. How can I find out if he filled out the form and sent it in? My husband hasn't received any news from USCIS and is supposed to have sent his application in May.
Okay, well, there are two ways. You can go on to a website from anywhere in the world, and it's uscis.gov. Those are the initials for the Immigration Service, the branch that grants benefits. And if you got a receipt, you can plug it in. It'll tell you where it is in the case. Now, if you've received nothing, I hope that you paid the immigration fee that goes along with the I-130 by money order or check. You can get a tracer on your money order or check, and immigration stamps the back part and it puts a number that belongs to you. In other words, you're assigned a case number, and with that you can track your case. Now, if you gave, let's say you gave that so-called lawyer cash and you don't have a way of tracing it, then it's almost impossible to find out if you have a case at immigration. You're going to have to ask that person, if they did file it, that you want copies of the file. It doesn't matter if he's a lawyer or not. He should give you copies of your application, copies of the money order or check that he sent with the application, and maybe this way you can find out and trace it, and also let them know your current address so that this so-called notary or so-called lawyer will send you an email and scan the receipt from immigration with the case number. You can also refile and start all over again, but I would hate for immigration to have two applications. So I would confront this person and say, have you filed it? If you did, I want proof. If they don't give you any proof, that means he hasn't filed it, and say, stop, I don't want you to continue the process, and get somebody reputable to help you.
Omar, if you've already petitioned a family member and are in the process of legalization, will the RAISE Act affect this?
We don't know that, Omar. I don't know. I'm hoping, of course, that the RAISE Act doesn't even happen, but I'm hoping it's not retroactive. If it does, that they'll say, okay, and it's something that they're going to phase in. I failed to say at the beginning. It's not, let's just say it passes in 2018, heaven forbid, but it passes. It's not all going to happen, all the cuts immediately. They're going to be phased in. Over 10 years, they want to reduce the numbers. So I don't know if phasing in also means, okay, in the first year, we're going to cut a certain percentage of those that are applying, and so forth until 10 years. We have no family immigration as it used to be. So we still have, I mean, this is a proposal, so there's still a lot of blanks in it. But as I learn more, of course, I'll share with you.
Renieri. Hi, my question is why my immigration lawyer recommended my wife and I so that we can submit the waivers I-601 and I-212 at the same time. Is it faster for users to approve them, or what is the reasoning behind this?
Okay, first I'd like to briefly explain what they both are. An I-601 is an application that is filed with the Immigration Service to pardon illegal presence in the United States. Even somebody came in legally, but they're now out of status, they need a waiver, and that's the I-601. The I-212 is for people that have had prior deportation orders. Now, I don't know when your spouse was deported, but there's certain cases where you can file an I-212 here in the United States along with the I-601, and there's certain cases where you have to file it abroad when you're outside already at the American Embassy. So some lawyers, if you're eligible to do both, do it for expediency, for efficiency, file them both at the same time. However, if one's denied, the other one, even if it's approved, you still can't go to your final interview, you're going to get denied. So if it's lawyers, we have different tactics. If I think that the possibilities of getting an approval are slim, I might want to file one first. Then once I win that, we'll go with the second one. If it looks like a good case and it's viable to get both waivers, I may want to file them both together. Again, every case is different. Don't let anybody tell you that they had a case exactly like yours and they did it ABC way, because in your case, it may be a different route.
Julio. My wife and I applied for the Visa U last November. This November, it'll be a year. How long does it usually take to get the work permit while we wait to get the actual Visa U? Do we need to apply for it while we wait?
Okay, the U visa is taking about 3 years, maybe even 4, and I've seen in my cases anywhere after about a year and a half or 2, Immigration Service will send the applicant a letter stating that they're eligible to apply for the work permit. So you have to wait for that. It's kind of like an invitation, and it takes about a year and a half to 2 years.
Jesse, it's been a year since we filed for my husband's green card. If the RAISE Act comes into effect, would this affect him in any way?
Wow, just what I didn't want to do, and I'm not saying I did it. Of course, the media has been all English and Spanish about the RAISE Act, and people are getting very frightened. Remember, it's a proposal. It still has to go through many steps. It still has to pass the Senate and the House. And we're thinking, those that are very involved in immigration, that the chances of, or the likelihood of it passing are not that good. So please, please try to relax. It's important that you know what's happening, as I said earlier, but don't start losing sleep over it and thinking that you may not be able to conclude your case. Now, my belief is that even if it does happen, it wouldn't happen until 2018. And by the time they implement it, it'll be the next fiscal year. So it might be a year or more, and hopefully those that have acted quickly and swiftly and have taken action to file an application will be able to get their green card and be approved before this takes effect. Again, my hope is that it doesn't, and a lot of my colleagues feel the same way.
Francisco, I have an I-130 petition, but there's a training I'm supposed to take in the U.S. Can I ask for a tourist visa?
So I assume you're abroad, you're somewhere out of the United States, and you have an application, somebody's filed an I-130, means you have a relative that's trying to get a green card for you, and you want to come to the United States for training, and you don't have a visa currently, so you're going to go to the embassy. Yes, you can apply for a tourist visa. Just note, if I'm the American consul and you're before me, and you're telling me that your parent, your sibling, your spouse is getting you a green card, but that you want to come for this conference and you want a temporary visa to come in, I may say, is he just trying to come in legally and he's going to this course, then he's going to stay? Because he obviously wants to get a green card. He has a process already pending. So sometimes it diminishes your opportunities to get that visa, the tourist visa or temporary visa, because you already have an application pending. With that said, now you know that if they may want 5 documents to prove that you are in your country and that you're not staying, I would take 10, because they're already going to be a little suspect of you because you have an application. And please make sure to take documentation, enrollment information, brochures about this lecture and conference, so that it all matches, and also show them what you have back home. So this way, if they say, well, you're just coming to finish your case, finish the life of your case through the green card in the United States. No, I have a job, or I'm in school, I have properties, I have a lot of things back home. I'm not going to abandon any of it. I just want to go to the conference, go back home, and then I'll wait for my turn to get my green card through whatever relative or employer is petitioning for you.
Brianna, after I receive approval of an I-601A, about how long would it take for an appointment in Honduras?
Okay, Tegucigalpa, which is the American Embassy, is in the capital of Honduras. Once you get the I-601 waiver, which is a waiver that is given to you because you've lived here out of status, usually the next step is the National Visa Center, or we call it the MVC stage. They're going to send you more documents and applications to fill out and some payments to make. And then once all that's done, which usually takes a few months, 2-3 months, then Honduras, the American Embassy, will send you the interview. So I would say roughly between 3 and 6 months.
Francisco, I-485 was applied from a sister, and I-130 for Mexico. It's processing, and I would like to know how long it would take. This application was filed on 1997.
97, and they don't say what country they're from, right? I assume it's Mexico.
Mexico, yes.
Good. Mexico is currently calling September 15th of 97, and you can file an application. Let me see if I have the dates for the application filing, which are different from the date when you're going to get your green card. And they're also on September 97, I believe. Yeah. So right now you can file the application, get a work permit, and you already have your I-130, which is the initial application that was filed way back in 97. Now when it's your turn, you can file the adjustment, which is the I-485, and that's when you're allowed to get a work permit, and then you wait your turn. Usually it's 6 months, but if your priority date in your particular case isn't current, you still have to wait your turn. And the priority date right now for siblings from Mexico is September 15th, 97. So sometimes they let you file the application before, so that you can have a work permit, but you still have to wait your turn. So if your date is not September 15th of 97 or before, you're going to have to wait until the bulletin says it's your turn. So it's not really by time, it's by visa bulletin.
Mario, A person who has 20 years of living in the U.S., is not married to a U.S. citizen or resident, has no children, and has TPS. What would be the way to become a resident?
Well, let me first tell you that TPS does not automatically turn into a green card. It was way back in the day, in the early 90s, there was a TPS that later you would be able to turn into NACARA, which turned into a green card. But if you got the TPS of 2000, 2001, unfortunately there is no hope for that turning into a green card as of now. It could be in the future, but as of now. So basically, if you are single, if you married someone that's a resident or a citizen for love, not just for a green card, then of course that person can petition for you. But just being here a long time and having TPS unfortunately does not add up to a green card. Please, I strongly recommend that you every 18 months you're renewing your TPS. We don't know what the future of TPS is, and I have some news later about TPS and the benefits that some people can obtain. But in your case, you tell me that you have no family relationships, so I would just continue every 18 months getting your TPS renewed, which is a work permit and allows you to live here. And sometimes even travel, but don't travel until you speak to a lawyer, because some people with TPS get an advance parole and travel, then they can't come back in. Very well. Well, the second topic, the news, the good news. This happened a few weeks ago, but we're kind of celebrating now because this was a Ninth Circuit case, and they decided in favor of the immigrant community, but we were waiting to see if the government was going to appeal it, and maybe we would lose it. Fortunately, the date for an appeal ended, and this is the Ramirez case, and this, what was granted, was something very favorable for people that have TPS, that are currently possessing their TPS work authorization. And it says that if someone is married to a United States citizen, and that person could have been born here or later naturalized, but they're citizens, or they have children that are U.S. citizens, also either they were born here or they naturalized, and they're over 21, they're able to immigrate in the United States. They don't have to go to El Salvador, they don't have to go to Honduras, they don't have to go to Nicaragua, which are the countries that are favored with the TPS, and then get a waiver and then have to leave and be out for weeks or months or years. They can do everything here. Basically, the judges said, for us, for this court, a TPSer is someone that, it's like if that TPSer came in legally. So basically they've said carte blanche, it's like you came in with a tourist visa, a student visa. So because you came in legally, now you can adjust your status and get a green card in the city you live in one of the 8 states of the Ninth Circuit. Now this is not for the entire country. There are 2 circuit courts that have decided this, the 6th Circuit, which is in the Midwest, kind of, and the Ninth Circuit, which is the West Coast, which is Alaska, Hawaii. It would be, let me see my geography here. It would be Washington, Oregon, California, Arizona, Utah, and Montana, I'm almost sure, are the states. And you can go online and just Google Ninth Circuit Court of Appeals, and it'll give you the 9 states. So if you reside in any of those 9 states and you have TPS and you're married to a citizen, or you have a child that's 21, that child can now turn around and get you a green card in a matter of months, all in the U.S., in the immigration offices in one of those states on the West Coast. You don't have to go back home. You don't have to risk not being able to come back in. You don't have to ask for a waiver. So this is excellent news. The government did not appeal. So again, if you're married to a U.S. citizen, or if you have a spouse that has a green card, don't say, oh, that doesn't apply to me, my wife, my husband's only a resident. Let's check to see if they're eligible to become a United States citizen. Many green card holders can become citizens and just haven't because they think they can't, or they don't know enough English, or they're disqualifying themselves without being advised by an immigration attorney. So maybe the resident that you're married to can become a citizen, or maybe your child is, say, 25 and he has a green card through his wife and now he's eligible to become a citizen. Let's kind of give him a little push to become a citizen. It's good for them, and now they can immigrate you as a parent. If you have TPS and you are from one of the 3 nations in Central America, your TPS is current and you're in the 6th or the 9th Circuit of the United States. So excellent news. I'm very happy for a lot of people. This will affect hundreds of thousands of people, so please spread the word. This is very good news.
Jessica, What should one do to be ready for the interview process?
Great question, Jessica. Now, you're not telling me if it's an interview with a judge, if it's an interview with an immigration officer, if it's an interview at the American embassy in your home country. So I don't know enough, but briefly, I'll globalize kind of the answer, and it applies to all three appointments. If you're going to court, obviously you need to take an immigration lawyer with you if you're going to see a judge. Very important. Don't go alone, or go alone the first time and ask for an extension to get a lawyer and then show up with a lawyer. But if you have an interview before the USCIS, which is immigration, or you have an interview abroad at the American embassy before a United States consul, very important to be prepared for the interview, to review all the documentation that was filed prior, not just the documentation that you're preparing for that interview, but many individuals have had applications pending for years that are now coming to an end. You review everything from the past, and you review them so that you kind of are familiar with the questions, and when they ask you, you're not saying, well, I think I lived at this address in that year. You already remember, and you have that down. Very important to review your entire packet, the birth certificates, the marriage certificates, the divorce certificates. Make sure you have originals and copies for the officer so they don't take your original away. I would suggest that you seek immigration counsel, especially if you've done this on your own or you've gone with a notary or some community-based clinic, that you seek immigration counsel, even if it's just to talk to the lawyer and say, I'm almost going to my interview. This is what they've told me. This is what I've had. What do you think? Should I go? Should I postpone the interview? Should I not go because I may be detained? So you want an immigration attorney to kind of look at things before you go. So very important. I say being prepared is key, and having all the paperwork that is necessary also. You don't want to go to that interview and the officer or the consul says, oh, you're missing this document. Send for it from the United States, and when you get it, we'll have another interview for you, and a month goes by. Or you're here and you're finally getting so close to getting your green card, and the officer says, well, we'll give you 90 days or 6 months to turn in the documents that are missing, and now you have to wait more time to get approved for the green card. And if it's citizenship, you definitely want to review the application. It's 20 or 22 pages long. You want to review not just the N400, not just the questions, for citizenship, which are 100 questions, but you want to review the application N400. And you want to review it. Why? Because there are a lot of questions that come out of that application for your citizenship exam. So a long question, and I'm kind of multitasking here with the possible scenarios. Next time, please be a little more specific of where exactly is your interview, and I'll be happy to zoom in some more on that.
Lupita, can I apply for citizenship since I've had my residency since 1984 from a low-income family?
Absolutely, Lupita. I mean, it doesn't matter how much you make, and if your family's all low income, citizenship, and I don't know why people get this misconception. You can actually be living on welfare, or you be getting some kind of public assistance, and you're still eligible to become a naturalized citizen. You could have gone bankrupt, and you can still become a naturalized citizen. So I think people get confused because to get a green card, there's certain requirements of income that the petitioner has to have, or in some cases the beneficiary, and that confuses people, and they think it's the same standard for citizenship. Not so. So please, if you don't have any crimes, you haven't been out for long, you didn't commit fraud in getting your green card so many years ago, it is way time that you become a naturalized citizen. But I recommend that you seek counsel just to review, make sure there's nothing there that might impede you. But the fact that you're low income absolutely does not matter for citizenship.
Neida, my boyfriend was detained by ICE and he made bail. What is the probability of him staying in this country? He has gone to 2 court dates. One of them is pending. It's until February, and it's for 2 DUIs.
Wow. That's a tough question, and I need to know a little bit more, and I recommend that you seek counsel and you talk to at least a couple lawyers. However, the fact that you were bonded out does not mean that you can stay. It just means that an immigration judge has decided that you can be free to go to work, to be with your family, while you have an immigration hearing and a final trial. or a merits case is what it's called. So you still have to prepare for it. Now, whatever you're asking for, they're going to look at your fingerprints. They're going to look at your background. They're going to do a thorough background check. And if you have DUIs or any kind of priors, of course it may affect the outcome of your case. I always tell people that are going to go before an immigration judge and have any kind of priors with the police or with immigration even, like deportations, or with the police, or have criminal records that they've been convicted with a criminal judge, I recommend that you get those records and you seek counsel, and you seek 2 lawyers. Not 2 opinions, 2 different types of lawyers. An immigration lawyer that will help you in the hearing, and a criminal lawyer that may be able to modify some of your past convictions, to soften them, modify them, vacate them if possible, so that you look at your best when you go before an immigration judge. And lawyers can sometimes get extensions and get continuances when you go to court. So don't think, oh my gosh, my hearing's in a month, I'm not going to have time to see a criminal attorney. Ask your lawyer to ask for continuance, and you tell the judge why, and many times they'll give you more time.
And this is the last question from Eptali. My husband already put the fingerprints for the I-601A. This was 2 months ago. How long does it take for the approval? His case is in Illinois. I'm a U.S. citizen, and we also have an American child. He's from Honduras.
Very well. The I-601 waiver is, it varies in time for approval, and it doesn't have to do too much with the fingerprints, but from data filing. And my experience is a really quick approval, 3 to 4 months. Average 6 months, and some can take up to 9 months. Remember, different officers work at different speeds. Different cases require different investigation, different depth of analysis for them to decide if you deserve or not the waiver. So my take is usually about 6 months is the average. Well, our time is up. Gosh, it flies. Excellent questions. Thank you. Thank you very much for your questions. Remember that on Thursdays we do have the same free advice, I call it, Facebook Live, but in Spanish at 7 p.m. West Coast, 10 p.m. East Coast time. So please spread the word. Please like my Facebook page. Please go to my website, almarosanieto.com, where you can find videos. Unfortunately, right now they're in Spanish, but I promise you they're being edited. They're already taped. And within a week or so, we'll be putting in the English versions that hopefully will be helpful, general information on immigration law. Very nice to be with you and spend an evening with you, and we'll see you next Tuesday in English and next Thursday in Spanish. It's messed up a lot of things. Yes, we're recording the TPS. ¿Oyó cómo prendió mi teléfono, Yude? Sí. Está apagado. Dicen que está poseído en Miami. Qué raro, nunca he hecho eso. Me asustó, está apagado. Como que Siri o algo entró. Wow, that is so weird. Dame un segundito. Me acaban de recordar de algo que tenía que hacer y no lo hice. How long do I have? How long do I have? Okay. Okay, done. Listo. Very well. ¿No te escucho, Iván? 2 minutos, sí. ¿Listo? 5, 4, 3, 2. Muy buenas noticias para la comunidad salvadoreña, nicaragüense y hondureña que tienen el TPS. En el 9º circuito, y recalco, solo el 9º circuito que comprende 8 estados en la costa oeste de Estados Unidos, el juez dio un fallo favorable para la comunidad con TPS, pero hay ciertos requisitos. Lo favorable fue que van a poder inmigrar las personas que tienen manera de inmigrar, lo van a poder hacer dentro de Estados Unidos sin tener que ir a su país de origen y pedir perdones y correr el riesgo de no poder volver a entrar. Le llaman ajuste de estatus. Ahora, ¿quién puede acogerse a este nuevo fallo? Se llama el caso Ramírez del 9º circuito. Personas que viven dentro del 9º circuito. Y por cierto, un paréntesis, el 6º circuito, que está también en Estados Unidos, también tiene algo similar. Pero lo que acaba de pasar hace unas semanas y favorablemente el gobierno no apeló hace unos días, es que las personas que tienen TPS y están casados con un ciudadano americano, y ese ciudadano puede ser nacido en Estados Unidos o naturalizado, o tienen hijos mayores de 21 años, ciudadanos, van a poder recibir su residencia dentro de Estados Unidos. Lo que la Corte realmente dijo es que el que tiene TPS todavía en pie es como que hubiese entrado legal con visa y por lo tanto, por tener entrada legal, puede hacer un ajuste de estatus e inmigrar dentro de Estados Unidos. Así es que favorable, muy favorable esta decisión. Estoy muy contenta para la comunidad que tiene el TPS. Y también no se desanime si está casado quizás con una residente, hay que hacer la persona ciudadana para que usted pueda inmigrar dentro de Estados Unidos. Así es que corran la voz, una decisión muy favorable para la comunidad de TPS de Centroamérica. Recuerden que tengan